Well, good morning, everybody, to the July 2022 Rafi Law Firm Mike Rafi webinar. Today, the title of the webinar is about negotiations, but the way I really want you to think about what we're going to talk about is under pressure. And depending on your age reference, you may remember do. My dog's looking at me like I'm crazy. That may be the song Under Pressure to you. If you are younger, and I think I'm on the cusp of this, I know it kind of from both, but I said that to somebody the other day, kind of just talking this webinar out and what I was going to say. And someone goes, "You mean Vanilla Ice?" And I went, "What?" And they said, "Yeah, do. And that was, I guess, famously what Vanilla Ice said, why his song was different. So anyway, we're going to talk about how to negotiate. And in that context, the real theme, frankly, is going to be keeping the other side under pressure. Because if you're negotiating without pressure, you're talking to a wall, and you're certainly not going to get that wall to do what you want it to do, which in our case, which our situations, is to pay money. I'm always, frankly, jealous a little bit of the divorce lawyers out there or the business negotiators who are negotiating, complicated sales of businesses, because they have a lot of moving parts. In a divorce case involving kids, for example, you may trade this for, you may trade money for parenting time. You may trade Christmas visit for keeping the house. I don't know, but in our world, in the personal injury world, most times, there are certainly times there are other factors at play, but the overwhelming majority of time, the only thing that matters, and the only thing that you can get for your client for that matter is money. So I don't want to be, I don't want to ignore the fact that this is about making more money for you and your client. And I won't be shy about that either. I mean, this is what the goal is. It's about making more money. And to do that, you need to get your David Bowie out, and you need to go under pressure. You need to make the other side be under pressure. Before I roll into how to do that, I am not going to touch on things like pre-suit demands. I need to do a new webinar in that, given that the statute 91167.1 has changed since the last time that I've touched that issue. But I'm not going to talk about that. I'm not going to talk about really any of the things that you need to do to effectuate a proper demand. So this is going to be more of a, I've been trying to think of the right word. This is going to be more of a wild west. Let's figure out how we can make some money for us and our clients in our cases. And a lot of times, there isn't a perfect way to do that. And I want to say that at the outset here. I've ended webinars saying this kind of same idea, but I want to say it here. I'm going to give you some ideas that have worked for us. I will fully admit to you that what I've done in one case on a Tuesday hasn't worked in another case on a Thursday. Seriously, same situation. I've even had cases where same insurance company, same defense lawyer or adjuster, pretty damn similar case, and I've done the same thing within a pretty short time period, and one's worked, one's hasn't. So I don't want you to think about this topic as this is the way to do it. I want you to think about this topic as this is a tool that I have which may help me get this case settled for more or quicker or both. So I don't even know what to call them. Tactics feels weird, but frankly, they're just ideas. The ideas that I'm going to share with you should be layered. They should be coupled, because if you try idea one and that doesn't work, try idea two, try idea three, try idea four. And I'll give you some real world examples. Got my phone down here as a cheat sheet to go through how we've done this. So the reason that I thought to do this webinar this time is because literally 1 year ago and a day, so July 13th, 2022, I wrote my law firm kind of like a summer State of the Union, which I'll do from time to time. And I talked about in an email form, and then later talked to the team about it. But I wrote out a pretty long email. I kid around. It was a 2-cigar email. I had to sit there and smoke 2 cigars in order to get this one out. But in that email, one of the main topics I talked about, it's the topic I spent the most words about, was risk and pressure. So I figured I was revisiting that email now a year later as I think about what I'm going to write to my team about how this summer and so far this year has gone. And I wanted to revisit what I wrote a year ago. And to be honest, I read that email and I went, shit, I forgot about that. I forgot, and little things in the email. I forgot to do that. I haven't been putting that top of mind. Man, I can't believe I haven't done that in the last 6 months. So it was a refresher for me, and I want to share it with you guys. So the most often question I get from lawyers during COVID was, because we were still putting our results out, at least some of them, the ones we could, and we were still talking about the cases we're having. And I was still doing webinars talking about settlements and things like that. But the number one question I got during COVID was, how are you guys settling your cases given COVID? And since COVID has stopped us from getting into courts, or did for a significant amount of time, creating pressure without the threat of a trial was really my focus for almost 2 years, because I needed to settle these cases just like you did. And we needed to get maximum money, and we needed to do so for a lot of people pretty quickly. You know, I'm sure you had a lot of clients who couldn't hang on for 2 to 3 years extra. I talked to a client recently, kind of what I call our last COVID delay client, where this person was on a trial calendar for March or April of whatever year that'd be, 2020. And that person's case was significantly delayed. So that's kind of our last real huge significant COVID delay. So those lessons should be carried over even today, because we still have delays in courts. We still have a large backload. And just in general, it takes a long time to get a case from start to finish. And if it's in a client's interest to find out if we can settle the case as quickly as possible and for how much. So the first part of the creating risk dynamic is the most labor intensive part. To create risk, you have to know every detail of your case. When I do these webinars, or when I don't know, I've done cross-examinations before, and other lawyers or whoever have come up to me afterwards and said, wow, that was amazing. You did all that off the top of your head. That was so great when that witness said this, and you just went down that road and, did it without notes and knew everything. You are so good on your feet. And I used to hear good on your feet. And for a very long time, I was kind of offended by it, funny enough. And that was because that meant to me like people thought I was just unprepared, that I'd show up and say, well, shit, I can figure this out, and then just do it. In truth, the exact opposite was true. The exact opposite was, and I hopefully is still true. I like to be the most prepared person in the world, because I think if I am, then I can look like, I can seem like I am good on my feet, even though in my head or in my mind or even out loud, I've practiced what appears to be some off topic, off the main beaten path, topic or question or answer. It seems like, that would never come up. But if I've thought about that and played that out in my head and practiced that, then it may seem like it's on the off the top of my head, but in reality, I've played that out in my head because I'm so prepared. I'm not going to sit here. I just want to give that little story. I'm not going to sit here and tell you, prepare your case, and go through and spend a lot of time. You have to be the most prepared person and the most knowledgeable person about the case. As you are learning about your case, you need to be thinking about what the pressure points are. What are the key pieces of information that you need? We have a case right now where I'm thinking of how much I want to share or how much I should, but let's just we have a case right now where we have delayed on a demand for about 8 months. We filed the lawsuit. We are now pretty much closing out discovery, and we have not sent the demand because we need to know certain information. And we've known it we've known for the most part what the information was going to be, but we wanted to make sure we had the information and could include it in a demand because we thought that that made the most pressure. Because if we would have sent a demand 3 months ago, I don't think it would have been unreasonable for the defense to not accept it. When you think about pressure, you have to think about who you're dealing with, who is the other side. And I will submit to you that there are three people, entities, whatever you want to call them, that you should think about when you are trying to put pressure on. So first is the pretty obvious one. That's the insurance company. And when I think insurance company, I think insurance adjuster. Because while we, on our side, like to say, Allstate's $1 billion company, Allstate as a company isn't really who you're fighting. What you're fighting is that chain of command within Allstate. It's the insurance adjuster, the next level of the insurance adjuster, and maybe the next level or whoever. It's that tier of people. And spoiler alert, I'm going to talk a lot about pressure on people and how you do that. But the second person that you have pressure on is the defense lawyer or the defense firm. The third is the actual defendant. There are many, many times you should create pressure on one or two or all three of these in different ways. And that's because they have different motivations. The insurance adjuster's motivation is to, and I'm giving you some ideas. I've never worked at this job, so this is what I imagine. If you have and I'm wrong, let me know. So the insurance adjuster's motivation, well, let's start even from the top. The insurance company, their sole motivation, save money. That's it. Which is just opposite to your goal. They want to save money, take a long time. That's opposite to your goal. But let's talk about the insurance adjuster, him or herself. That person's goal, I imagine, goals, plural, are to do a good job, keep their job, do such a good job they get a promotion or a raise, be able to go home and not be stressed out about their cases. I don't know, make a friend, enjoy picking up the phone and calling you. I think those are the main ones of an insurance adjuster. The one that I focus the most on, maybe it's just my personality, or maybe it's just the kind of cases I have, or maybe it's because it gives the best leverage, I think. The one that I focus the most on is this person going to have to go to their boss one day and say, I really messed up. I really, really messed up. I didn't accept or make or whatever a settlement offer. I didn't settle a case when I could have. And now I have a really, really large verdict that I have to explain. Obviously in COVID, that one was challenging. So, the other ones are that this person, wants to have easy cases, or this person doesn't want to be bothered, or this person just wants this case over with so you can go away. So those are other ones you want to focus on. Let's look at the defense lawyer. It's similar-ish to the insurance adjuster, but the defense lawyer, and a lot of us on this chat have been defense lawyers. Goal of a defense lawyer, at least this was my goal, was to do excellent work, still my goal. Bill my hours, kind of my goal. I want to work, as much as I need to work, and do a really good job so that way I keep getting clients. Now, remember, the insurance company is the defense lawyer's client. And I'm talking on the business side. The insurance company is the defense lawyer's client. So if you can put pressure on that relationship, the relationship between the defense lawyer and their real client, the one paying their bills, the insurance company, you are going to have success, because the defense lawyer's biggest fear is losing that insurance company client. Now, do you really have a chance to, on your average ordinary case, do you have a chance to affect that relationship to the point where that person might not be getting any more cases from the insurance company? No, probably not. But do you have a chance to make that defense lawyer think that that relationship is or could be in jeopardy based on the outcome of the case? Yeah, I think you can. And I'll return to all these in just a few minutes. On the other side, I guess on the third side of the coin, if such a thing exists, that's the defendant. And the defendant's job, I guess the defendant's job or goal in a lawsuit is to get out unscathed, right? If the defendant has insurance, their job is keep it in the insurance limits, get us away from that. I think that I think that we as a category of lawyers, as plaintiffs lawyers, and I see some defense lawyers on here, so hello guys. But I think we do a very poor job of educating defendants. I'm going to say that again. I think we do a very poor job of educating defendants. I bet a few of you are thinking, what the heck is he talking about? How would I and why would I educate defendants? The reason is because defendants can be your ally. They actually are most times your best ally in getting the case settled at or inside somewhere the insurance policy limits. And that's because a defendant, all they want is to come out unscathed without having to pay any money. And as an added bonus, if they can settle the case even quicker, then they don't have to worry about the headache. They don't have to worry about the headache of going through the litigation process. They're not going to be deposed. They're not going to have to go to trial. They're not going to have to explain to everybody in the office, hey, we're being sued. They're not going to have to do all that stuff. So the defendant needs to be educated about what their role is, because a lot of defendants don't know that their goal should be to come out unscathed. So I'll talk about how to do that in just a few minutes here, but let's pause and remember that these three players on the other side all have different motivations. And as you're educating yourself about the case, you need to be looking at pressure points between and among all three of these, because that's how you're going to get the case settled. Of course, disclaimer, of course, you need a good case. You need to have, a defendant who did something wrong. You need to have a plaintiff who's actually injured. You need to have a plaintiff who, has little to no contributory negligence or, however, comparative fault, whatever jurisdiction you're in. You need to have a case. You need to have a case. This conversation is in the context of how do you take that case from a fake numbers, a $500,000 settlement to a $600,000 settlement, and how do you do that 4 months earlier than you traditionally would? Here's the thing that's brilliant about this whole conversation. I say that kind of tongue in cheek, and what of course you have to remember is that you will never know how much the case would be settled for, or will settle, or how quick it would settle for, if you did something else. So, if I would have done this, maybe the case would have settled. You don't know. So as you're going through this, don't second guess yourself. Don't worry about, like I said earlier, doing it the perfect way. There is no perfect way. Look at your tactics, your ideas, look at how you implemented them, reevaluate them, and then try again. And that is the magical thing. And that's why lawyers who start conversations with, well, I've been doing this for 30 years. I'm like, shit, I don't care. I did something last week and then I tried it again this week and it didn't work. I don't care what you did 30 years ago, because that probably won't work today. That's just that's half me venting about some lawyer who is bothering the crap out of me. All right, so let's talk about insurance companies. I said this a little bit, but I want to make it explicitly clear. I think the number one motivator of getting an insurance agent, an insurance adjuster to settle a case is to make that person worried that down the line, they're going to have to go to their boss and say, don't worry, I told you this case was only worth $100,000, but the verdict came in and it's $500,000. That I would imagine is the worst thing that can happen to an insurance adjuster, that they have to go down the hallway and have that conversation. So you want to put pressure on that person to make that decision repeatedly, I mentioned this a very long time ago, like 2 years ago in a webinar. So I'm going to say this story again, because I think it's the best story on this topic that I have. I had a case where there was a $500,000 insurance policy. And looking back, by the way, I didn't do a great job putting pressure on that defendant. Talk about that later. But we had a $500,000 policy that we were after. I think my client had about $92,000 in medical bills and had an arthroscopic surgery on his knee. It was like 92 or 93. Um, Most of us probably, if you're just kind of doing the typical, medical bills times 2 or 3, that bullshit. Or if you're, just saying, what do I think I can get off the top of my head? 500 is probably not the answer because there really wasn't much heat in the case. There wasn't, much reason for the jury to give, quote, mad money, which is money that they give when they're angry and they want to punish the defendant, even in the compensatory damages phase. So in that case, I had to figure out some way I'm going to put pressure on somebody. And again, looking back, I could have done a better job on the defendant. The defense lawyers, I don't think they really cared about the case. I think they were at their stage of their career where putting pressure about a relationship that they frankly now don't have because they've both retired, or at least the lawyer handling the case retired. I don't think he was going to care if I said, hey, so-and-so's not going to send you cases anymore. That's not what I would have said, but I don't think that was the way to approach that. So then you're left with the insurance company. And what I decided to do was send demands and send a whole lot of them. By the time the case eventually went to trial, but it went pretty quickly. We were in trial in less than 26 months. It was right over the 2-year mark. I was in Cobb County. By that point, I'm pretty sure I had sent, and I started this midway through discovery. So it wasn't some brilliant idea I had at the beginning of the case. But in the middle of discovery, I started sending demands. And I sent 17 of them, I'm pretty sure was the number. It might have been up to 19 because I actually made 2 during the trial. But my reasoning was, and eventually my demand letters, they started with a traditional, here's the demand, here's the facts, here's this. And what made me think about this is I had done a pretty comprehensive demand, and then I found this witness. And that witness said some great things I already knew, but said it in a way that was really helpful to me. So then I paraphrased that deposition, attached the deposition transcript, and sent a new demand. Well, then a month later, I was like, they didn't respond. And this was what was bothering me. They weren't even responding. So then I just sent another one. And by demand 15, these demands were like 4 sentences long that said, this is my 15th demand. I am still willing to settle this case within the 500 or at the $500,000 policy limits. You have not responded. When I get more than 500,000, the insurance company is going to be responsible for the entire judgment. This is your 17th chance to stop being, or 15th chance to stop being unreasonable. And that's what the demands eventually became. I wrote one, I think, that said, when there's a negligent failure to settle case, remember, it's not bad faith. Bad faith sounds like it's this much higher standard. It's just a negligent failure to settle. They just have to act unreasonably. They don't have to act with bad faith. So in writing especially, I'm using the phrase negligent failure to settle, or negligent failure to protect your insured. That's another good way to phrase it that I think works better for an uneducated jury down the line, your, quote, bad faith jury. But one of the demands just said, this is your whatever number demand. I'm going to show this letter to the negligent failure to settle jury, and they will see how many times you put your insured at risk. And then I'd give, another 30 days or another 21 days or whatever it is. We got to closing arguments in that case. And I was literally about to give my closing argument. I'm setting up the courtroom. I've got everything that I need. And I get pulled out in the hallway by the defense lawyers, and they say, hey, is that demand still on the table? It's less than $100,000 in bills. It's an arthroscopic surgery. My client is completely healed. There's no real significant, heat in the case. And I say, yeah. And then I get the money. I think there was a little discount, maybe it was $450, but and the reason is, and I eventually asked, I said, why is this? And they said this was because the insurance adjuster, as they were getting the reports, eventually said, I don't want to have to go to my boss or go somewhere and explain that I turned down, I think it was 19 total demands. And then there was a verdict above the insurance limits. What should I have done differently there is I should have, in addition, it's not really different. What else should I have done? I should have put immense pressure on the defendant. The defendant was she was probably late 30s, a late 30s. I forget if she had a job, but she was a very educated, well-articulate, married woman in her late 30s. She presented very well in Cobb County. Her husband worked, I think, at like Mohawk or something, the flooring place. But they were a very nice couple. I mean, they were good people. And I think that they felt very confident, probably because the lawyers were telling them, they felt very confident through the whole case that, don't worry, we've got insurance. This is within our insurance limits, not a big deal. And I think what I should have done, in addition to trying to put pressure on the insurance adjuster, is I should have sent 17 or 19, whatever it was, demands to the defendant. Now, disclaimer or precaution, you can't send a demand directly to a defendant when they have counsel. I just want somebody to send a demand and then be like, Mike, what the heck, as if there's an issue. So what you can do is you can send a demand or send an explanation letter through the defense lawyer to the defendant. And in these letters, what you want to say is what you're doing. You want to basically give a status update like it's your own client. Of course, it's a little different, but like it's your own client. And then you want to say the consequences to what the consequences that will result if something does or doesn't happen. So let's say on demand number 5, I would, for example, send to this defendant through the defense lawyer, dear so-and-so. I actually had a lawyer once tell me that I violated an ethical rule by writing dear, whatever the defendant's actual name was. I'm still going to write dear because I don't think that's an ethical violation. But if you want to be extremely careful, write dear defense lawyer, please share this letter with your insured, with your client, excuse me. But I wrote, dear Karen, attached is my 5th demand to your insurance company seeking to settle this case within the policy limits and to protect you. It may sound funny that I'm protecting you, but my goal, here we go. Hold on with me for 1 second, folks. This is what happens when I do this from home. Bunker. Y'all pause with me for 1 second. I'm so sorry. All right, now part 2 of the webinar as we continue after that commercial break from my dog barking. Let's get back to this demand that we were talking about, which is, or the letter that you'd send explaining to your, to the defendant about the demand you've just sent. You're going to write, dear Karen, attached is the demand I sent, and we are hoping to resolve this case within your insurance limits and protect you. Now, I think you need to explain why the heck you're trying to protect somebody, which is, you would say, Karen, I want to protect you because I don't want this verdict to be above your insurance policy limits. If that hurts my client because it's going to take a long time, and my client's willing to settle at your insurance policy limits, which will protect you and help them. In a way, Karen, you and my client have similar interests. You want to get this case settled and you want to do it at your insurance limits. So that way you don't have any adverse consequences. And then you have to do the hard part, which is say, and Karen, if this case is not settled within your insurance policy limits, you are in incredible risk. You may eventually, depending on the case, you may be saying you may lose, you may at risk your bank accounts may be at risk, your house. I mean, you got to say that. If it's a business, you want to tell them, hey, your business is in jeopardy. If I go get a verdict of what I think I'm going to get, that may require you to sell equipment, to lay off people, to reduce salary, to reduce money for yourself, to close up shop. Now, do those things happen on a regular basis? No, of course not. But those are the risks. And those are the reasons why people have insurance. So I think you need to highlight those reasons and explicitly say what they are. And you need to do so as directly to the defendant as you can, as directly to the defendant as you can. And I think the best way to do that, or at least one way to do it, the most common way to do that is going to be through a letter to the defense lawyer, and send it to the defendant. I will also suggest that if you've sent a demand or a few demands before the deposition of the defendant, you can also ask the defendant about the demands. Now, will you get objections? Maybe, probably. Will the defense lawyer tell their client not to answer those? Maybe, but can you still ask the questions and get your point across? Absolutely. Here you go, Karen. Here's Exhibit 7. Exhibit 7 is the demand that I sent to settle this case on behalf of my client. I send it to your lawyer or the insurance company. This is the pre-suit demand I sent to the insurance company looking to settle this case. So that way we didn't have to file this lawsuit. Have you ever seen this before? Karen says, no. You go, really? Did anybody tell you about this? No. Well, did you know my client didn't want to file a lawsuit and that my client was trying desperately to settle this case without having to do so? No. Did you know my client's offer was within your insurance policy limits, which would completely protect you? No. So you don't know anything about this? No. Well, here's Exhibit 8 and 9. Do you know about these two demands, these two other demands? No. And even if she says yes, the imaginary Karen, even if imaginary Karen says yes, your questions are, do you know why why these were not accepted? Were you consulted? Were you asked your opinion? Do you realize that these would protect you and that these would protect your assets? These would protect your financial future. So that is a way to create pressure on the defense, or excuse me, on the defendant. Overall, the way to create pressure on an insurance company, an insurance agent, is to write demands and to couple that with an explanation letter or a mirror letter, a letter that mirrors your demand, but I prefer an explanation letter to the defendant. I think those are the best ways because the insurance adjuster is going to get pressure, hopefully, from two people through that. The first is from you. You're sending the demand to the insurance adjuster. But what you're doing on the explanation letter to the defendant is I want that defendant to pick up that phone, call up Chubb Insurance and say, what is going on? Why am I getting letters that say that I might lose everything and you're not settling the case? I have insurance so that you'll settle cases. What are you doing? So I want that insurance adjuster to be getting letters from me and frantic calls from the defendant. Also, with educating the defendant, you can put the insurance, the insurance company's hand-picked defense lawyer in a box too. In that explanation letter, I like to give the defendant ideas that of things they can do to ask the defense lawyer things. Basically, you can say, and I say to the defendant, you know what I would do if I were you? And I literally write this. You know what I would do if I were you? I would ask your lawyer, your defense lawyer, for verdicts. I would ask your defense lawyer to explain to you what the so-called bad faith / negligent failure to settle process is and how it works if there's an excess verdict. I would ask your defense lawyer, what are the chances that you are faced with an excess verdict in this case? I would ask your defense lawyer if they can guarantee that the verdict will be within your insurance policy limits. I would ask your insurance company, will you promise to pay any verdict if you deny the demand for the policy limits? Because this explanation letter is coupled with the demand. If you, insurance company, deny this letter or deny this demand, will you promise to pay any verdict no matter the size? All those things require the defense lawyer and or the insurance company to put their money where their mouth is. It requires the defense lawyer to go to the insurance company and say, hey, I have to share this information. My client's asking for it, assuming the defendant does ask for it. The defense lawyer says, I've got to share this information. And look, honestly, I can't tell them there's a 0% chance. I've got to send them this verdict research that, and by the way, in the background, you can be sending verdict research directly to the defense lawyer. Send him the verdict research that you want him to send to the defendant. So the defense lawyer is sitting there going, I've got to share this verdict research that I literally have sitting in my inbox, which is 10 cases that are similar, that are all above, all verdicts or settlements above the policy limits in this case. Whatever you want to arm the defense lawyer with, sometimes you're arming them so that way they can voluntarily help you. The defense lawyer says, oh, send me jury verdicts and I'll pass it along and maybe I'll change somebody's mind. But you can also give them a grenade and pull the pin. You say, hey, in this grenade, here's this information. And if you don't share it, you've got a grenade that's going to explode, because if there is an excess verdict, and then I go down that negligent failure to settle road, you sure as hell know one of my exhibits is going to be this email where I said, here's the jury research I think is appropriate that you should share with your client. Here's the letter that I sent to your client saying, I sent your defense lawyer verdict information. You should ask him for that and ask him to find you more. And I'm creating conflicts or wedges, points of pressure between all these three people in this triangle that's preventing you from getting paid quickly. So I want to give you a couple examples about some settlement tactics and other ways to create pressure apart from this dynamic, with this certainly in mind as a background. But I want to give you a couple of case examples and some things that I've done. If you got any questions though in the meantime, or any comments, drop them in the chat. That helps me the best. And I'll take a minute and answer those. So I talked to you about more demands, and the example I've used about sending 17 or 19 demands. I always forget the number, but sending all those demands. I would say in a regular case, if that exists, a regular case, never say that word. I would say that we are typically sending, in a case that's not going to settle, very quickly, we are sending multiple demands. So that is something we routinely do. And part of the reason is there's no risk. You send more demands, so what? It doesn't hurt you at all. So once you write that first comprehensive demand, you can modify and resend that, or you can just send a simple, we are reiterating our demand and giving you another 21 days. Let's go real quick to mediation, because I think that's an interesting topic about how to create pressure. I am of the belief that your demands, your initial demands, no matter what the setting, should be as high as possible so you don't get laughed at. That's generally my belief, is that your demand should be as high as possible so you don't get laughed at. And the reason, and this is in a situation, a general situation where you don't have any clues about what the other side or how the other side values your case. Okay. This is especially true in situations where there is a large dispute, whether about whether your client was injured or liability in the case. And the other side's maybe saying to you, we're going to discount the case by that. In those situations, I want to start generally at as high as I can without being laughed at. When I was a defense lawyer, I used to say all the time during mediations, well, you all started too high. I'm not going to be anywhere near your midpoint. I can't start as a defense lawyer. I can't start below 0. So the number you pick to start with doesn't matter to me. And that is 100% true. That is 100% true. So a lot of times using a starting point of where I'm telling you, which is as high as you can be without getting laughed at, a lot of times that's going to leave you extremely too high, because the point of doing that is to make sure the defense isn't somehow willing to pay a ton of money, right? That you don't want the defense to say, you don't want to leave money on the table. If they're telling you, hey, we think there's a liability dispute, but in reality, in the back of the mind, they go, nah, we know we're going to be responsible for this, and we know we're going to have to pay. But they've been telling you liability dispute the whole time. Or maybe they've been telling you your client's shoulder's not really injured, but they know it is. You don't want to give up that option to find out. You don't want to give up the ability to find out if you can get a high settlement. So what I like to do is, as soon as I find out that I am too high, like significantly too high, I want to make a huge jump. So how do you find out you're too high? The mediator comes back in the room and he's laughing at you and he's going, "You're out of your mind." They said no, and they don't even have an offer or whatever it is. Or you make a couple moves and it's very clear based on the moves. I mean, I once did a mediation. I guess this is the story I'll talk about. It was a case where a doctor performed a procedure on a woman without her consent after giving birth. She had, and the procedure was removing her tubes. She had flirted with the idea, talked about the idea. She was having twins and she was in her mid-30s, and she eventually tells her doctor, and luckily this was in writing, in an email. She tells her doctor, me and my husband, we've decided not to go through with that procedure. Just want to give birth to our twins, and that's it. Well, doctor performs the tubal removal anyway. And in that case, I spent an incredible amount of time trying to value that case and figure out what I thought it would be worth, whatever that means. I was all over the map. So, and frankly, what my client wanted or was willing to settle for, what she thought was a good day, was lower than what I thought was a good day. So I was really the driving force in that case, saying to her, let's make sure that it's not a higher number. So I started at a number that was in the millions. I started at multiple or multi-millions. And it became very, very quickly that I was way too high. And the mediator was concerned that he told me that he was concerned I was in a weird situation where I was going to have to make this huge move to come down if I wanted them to continue to negotiate. And I said, yeah, it's not weird. I'll happily do that. And I think I jumped like $2 million and they were literally at like, I don't know, a couple 100,000. And I jumped down like $2 million. I don't know why. Maybe there's some lawyers on this chat that are like getting goosebumps or getting the chills or shaking their head. I don't know why that's such a big deal. And here's how it gets back to pressure. What I realized was that the number I was at was not putting any pressure on the defendant, or excuse me, on the defendant, the insurance company, the insurance agent. It wasn't putting any pressure on anybody. So I needed to put pressure. So I want to put pressure as quickly as I humanly can. And the way to do that is drastically lower the demand to an amount that makes them say, oh shit, he is serious. We are going to have to work and try to settle this case. I started a mediation I guess it's been 3 weeks ago now. I started mediation 3 weeks ago with a bracket. If you don't know what a bracket is, let me tell you real quick. Best way I know to explain a bracket is, imagine you're selling your car for $10,000. Some guy comes up to you and says, hey, I'll give you $1,000. You have two options. One option is to say to him, no, what are you talking about? The car's $10,000, get out of here, and just shoo him away. The other option is you say, hey man, you trying to hustle? If that's what you're trying to do, let's get realistic. If you come up to $8,000, I'll come down to $9,000. That is a bracket. You come up to $8,000, I'll come down to $9,000. And what you're doing is you are bracketing where you want to settle your case, or at least that's the idea. It saves you a lot of the nonsense. I'll use brackets sometimes just to, easy fake numbers. If somebody's at $1 and I'm at $200, I will say, hey, if you come to 150, or if I go to 150, will you go to 50? And we'll just at least pare down some of the nonsense. But more importantly, I like to use brackets to put pressure on the other side. So I started this mediation with a bracket. Didn't even start with a hard number. I said, I want to settle the case between this and this. Mediator's confused. I shouldn't say that. Mediator laughed and shook his head because he knows I like to try different things at mediation to create pressure. So he goes to the defense and they come back with just a hard number and no real take on the bracket. What does that mean to me? So let's make up numbers. If I come in and say on a first move in a mediation, and this is probably true even if you do a bracket later on. If I come into a mediation and I say, I want to settle this case between $750,000 and $1 million. So my first move is I'll go to $1 million. Let me phrase it right. If you go to 750, I'll go to $1 million. The reason I said frame it right or phrase it right is because how you say it determines whose move it is next. In a bracket, if you say you go to 750 and I'll go to $1 million, that means they went to 750 and then you went to $1 million. It's their move. If you say I'll go to $1 million if you go to 750, then you have the next move because they're going to 750, then you are going to $1 million. So make sure you're phrasing your brackets in the way that puts them back in the position to make a move. So anyway, I said, let's just use this as an example. I say, I will go to $1 million if you go to 750. Did I just reverse that? I did. Now I have myself all turned around. I basically gave him a 750 bracket to 1 million. I said, if you go to 750, I'll go to $1 million. There you go. I did it right. And they gave me a hard number back. What that means to me is that they two things. They either don't believe my bracket or they're okay with my bracket, at least in the sense that they're willing to settle the case for somewhere in or near my bracket because they don't think, if they believe my bracket, they don't think that they're wasting their time. If they only had $200,000 and I say 750 to 1 million bracket and they believe it, I would sure as heck hope that they leave and tell me, no, we're nowhere near your bracket. Now, if they have 500, 600, maybe they stay. If they have 650, 700, I'm almost certain they're staying. And if they have something within the bracket, they're also staying. A lot of people are probably thinking, but where do you do then? Where do you go? If you've given them an honest, which I prefer brackets to be honest. I always want my bottom line number to, as best I can, I want it to be within that bracket because I want to have the credibility through that mediation as well as others with that mediator and those defense lawyers that my brackets are real. So the obvious question becomes, what do you do next when you've given a real bracket and they just respond with, let's imagine, $200,000? Well, you reiterate your bracket. You say, okay, I'll go to 975 if you go to 775. That is the same midpoint, by the way, of the original bracket. So what you're really doing is it's a non-move move. You're telling them the same exact information, and that then they need to respond accordingly. You're telling them for a second time, this really is my bracket, guys. Now, on the third time, maybe you give them a little inch and you say, okay, I'll go back. I'll go to if you go to 750, I'll then come to 950. What have I done? I've moved the midpoint down just a hair, but it's basically the same damn information. I want to settle the case somewhere around 750,000, or excuse me, somewhere between the midpoint between 750 and $1 million. That's what I'm saying. So to me, that means I want to settle the case somewhere in the mid high eights, right? I mean, something like that. So that is a way that you can come out of the gates in a mediation, creating pressure. I prefer doing that rather than giving a hard number that's, I'm using air quotes here for anyone not looking at the screen, lower than or more reasonable than what you traditionally would see. I like a bracket because it gives you a range, and you can continue to reiterate that bracket or make non-moves. It also, if you have the credibility behind that bracket, because maybe it's something you do a lot, like I do, you do save a lot of time. The most frustrating thing to me about mediation is you're in hour 4 and they top out at $100,000 and you think the case is worth $1 million, and you look around and you go, what the fuck have I been doing for 4 hours? Like, why didn't you guys just tell me this? So with a bracket at the beginning, I want to be efficient with our mediation. And I think that's important because the longer that mediation goes in terms of time, the harder it is to create pressure or keep pressure. I want to come out of the gates with pressure. And my next move, I want to put more pressure. And in my next move, I want to put more pressure. Along with credibility and creating pressure, just as a side note, if you say you're going to leave a mediation, leave the mediation. Don't be the guy that stands up figuratively or literally at the table, puts their hands up, starts to stand up and goes, oh, okay, I'll stay. If you say you're going to leave, you have to leave, because creating pressure in any scenario is based on credibility as well. You have to be credible in what you say. Those were the main points that I want to say. I saw a question here about tips for putting pressure on the carrier after the liability carrier has already paid their limits and you're in litigation. You know, Georgia's very difficult because the statute limits the way that pressure can be created. Colorado, for example, is almost the exact opposite of that. Quote, bad faith exists with your own insurance carrier and not generally with the at-fault driver. I frankly think, or at-fault party, I frankly think it should be both ways. I think you should be able to punish, I don't know the right word here. You should be able to litigate against insurance companies for being unreasonable on both sides of the coin. But in the context, and forgive me to the defense lawyers that handle cases, because I hope this doesn't affect you negatively, although it's your job. The pressure points are limited. And the number one pressure point, I think, is when defense lawyers get a case, if there's not a ton of money, in dispute, and they think, this is just a case that, I'm not gonna have to work that much. I want to overwork the crap out of them. The downside of that is you have to work your butt off too. So I think giving the defense lawyer a reason to try to get that case settled is a helpful thing to do. You can have your client send a letter to the insurance company saying, hey, if you don't pay, you're going to lose a long-term customer. I've seen that done. I don't think the insurance company gives two shits. So I think that pressing the case forward to a trial, stipulating to a trial calendar, even if you're early, even if you haven't done your medical depositions, do that. Or if you think a pressure point is with the insurance company not wanting to spend money, start scheduling doctor depositions. Schedule, 2, 3, whatever your number is. Schedule those depositions, 90 days out, and then 60 days out if you can, and then send a demand that expires, a month before that. So send a 30-day demand. And then, you say in that demand, hey, in 45 days or whatever it is, you're going to end up spending $10,000, $20,000 in these doctor depositions. It's much better for you, insurance company, to save money here and just pay us what we want to be paid. So the leverage and pressure points are certainly limited, and that's unfortunately the world we're living in. But I think you want to try to get the defense lawyer on your team, and I think you want to try to find reasons that the insurance company would settle. Money and expenses seem to be one of those, and of course the threat of trial. So I hope that helps. What I will say to end the lawyer part of this, before I kind of give you my 2 cents on something else going on in the world, if you care to listen. If not, that's fine too. Putting pressure is not a fun thing to do. Putting pressure is not always a fun thing to do, because I grew up playing sports. In a basketball game or something, I could go at the guy I was guarding that was guarding me, and he could go at me, and we would go down the floor, bumping each other, maybe talking a little shit, maybe an elbow here and there. But at the end of the game, as long as we both played by what we understood the rules to be, a hard foul's okay, or, a little bump is okay. Then there was a lot of respect for each other. And I think that a lot of times is lost in lawyer world, because, and I'm going to make a very sweeping statement, Defense lawyers don't get it. Defense lawyers sometimes don't get it. And the ones that do get it, by the way, are awesome defense lawyers. They are great and phenomenal at their jobs. But to me, that's few and far between, at least about this one topic. The defense lawyers that don't get it are the ones that don't understand that my job is to make money for my clients, and that making money for my clients makes me money, and that my clients' recovery is also my recovery. You know, I had a lawyer once tell me, don't take this personally. How can I not? It's my money. So I take things very personally. With that said, though, at the end of the case, when I'm going to use the phrase when I've tortured you through this whole case, when I've sent you demands, when I've made you work, when I've told you you're wrong and that you're going to look, I say this in a much more diplomatic way, that you're going to look stupid by telling your client and telling the insurance adjuster that this case isn't worth what I say it is. When I go through that whole process, it's really pressure, 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 or attack, attack, attack. And it's the same thing. You have to attack to put pressure. At the end of the case, a lot of defense lawyers, frankly, are annoyed by me or insulted or hurt. They're not happy because their approach is, why are you making my life tough? Why are you doing this? And my answer is because this is how I do my job, because it is the best way to do my job, because I'm putting my client's interests, which mine are aligned with, first, and I'm getting as much money as quickly as possible, because that's all it is for me. Remember, I'm not a divorce lawyer. I'm not trying to get the house or the Tupperware or, get more child custody money, whatever, child support money, whatever. That's not what I'm trying to do. I have one goal. So the defense lawyers who don't get it will take personal offense to your tactics if you are repeatedly and consistently trying to apply pressure. And that sometimes makes you feel like a bad guy. It makes you feel like you're doing something wrong. So that's why I say putting pressure in the way that I say and doing it over and over and over oftentimes is not for everybody, because everyone doesn't want to have the risk of appearing to be, I completely disagree with this on its face, but appearing to be the bad guy or appearing to, or being disliked by somebody else. Because when I say that I'm going to work somebody to death, I start sending requests, meaningful ones. I start sending written discovery. I start scheduling depositions. I start sending demands. I start doing everything I possibly can to just pound somebody into submission. And if you're not willing to accept the consequences of that on a personal level, which is that defense lawyer saying, working with that person was not fun, was not the most enjoyable thing that I did. I don't think you're going to, I won't even cover it up. I don't think you should be doing this job. I don't think you should be doing this job, because I think if you're not willing to do everything in your power to get your clients the most amount of money, I don't think you should be doing this job. So I'm not saying this is the way to do it, but I'm certainly saying in certain cases, this is one of the better ways to do it, to put pressure on somebody. And from a personal level, sometimes there are adverse consequences. So I wanted to at least mention that to everybody out here. I just got a question, which is, do I use offers of judgment and offers of settlement? I'll tell you, the question was offers of settlement. I will tell you my secret, and not a secret, I tell the whole world this. I use offers of settlement and offers of judgment. When I want to settle the case, I send an offer of settlement. Makes sense. I want to settle, offer a settlement. When I do not want to settle the case and I want to put more pressure, more leverage on the other side, I send an offer of judgment. And that's because generally, no defendant wants a judgment against them, because with an offer of judgment, that is what happens. A judgment gets entered in a court of record and then they pay. They're also in an offer of judgment. There's no other terms. There's no confidentiality. There's no lien promises. There's no indemnity. There's no other terms. There is a judgment. And when I'll mention this, when you are negotiating, it happens all the damn time with rideshare companies, Uber, Lyft, Travelers, whoever you're dealing with over there. they want to put a lot of terms, a lot of non-monetary terms that are often significant to your client. You know, the classic Uber term is, traveler's Uber term is, you know, about, I call it a penalty. They say it's not a penalty, but a penalty for violating, you know, the non-disparagement or the non-confidentiality agreement. It's a substantial amount of money. So if you are getting a judgment, and remind them of this, hey, if I try this case and there's a judgment, there are zero protections. There is a judgment and there are no non-monetary terms. So when I want to settle the case, offer a settlement. When I don't, offer a judgment. To create more pressure, what I will do is I will send an offer of settlement and an offer of judgment at the exact same time, along with an explanation letter to the defendant. Here's how that works. I'm glad I got this question. This is something I should have said on my own. I send the offer of settlement for a number that my client really likes. Let's just use. I send that for $1 million and said, we'll settle for $1 million and we'll even subject all the terms you want. If you want your terms, you know, your whatever, your indemnity, your this, your that. If you want those non-monetary terms, you're gonna have to pay for them. So here's $1 million offer of settlement. If you want a judgment though, we'll settle for $750,000. It's $250,000. It's a huge difference. Do I think they're going to accept the judgment? No, because I don't think they want a judgment. But what am I really doing here? I am lowering my target for a future trial. I am lowering my target for a future trial. So now instead of having to get 125% of $1 million, 1.25, now I only have to get 125% of 750. Now I only have to get 125% of 750. So it's accomplishing two things on the pressure front. It's making them decide how much are these non-monetary terms really worth? And am I worried about the trial? And am I worried about having to pay attorney's fees and costs because somebody hits the 125%? And then the explanation letter explains what I just explained to you, to the client, to the defendant. It explains just on a basic level. This is why we did this. And in some ways I try to talk the defendant out of wanting to, or even considering agreeing to a judgment. So, hey, here are the negative effects of a judgment. Judgment does this possibly to your credit. It does this to this, and this. You list out all the negative things of a judgment. It's public. It's and go through the whole thing. So, and let's imagine the insurance limits are $1 million. So you say, hey, for $750,000, you can take this judgment. By the way, it's not your money. That $750,000, that hurts you because it's a judgment. Now, your insurance company thinks those terms are obviously worth money. So we have sent you an offer of settlement. That's $1 million. That's still, it's not your money. But you know what? That $1 million offer of settlement, it has zero adverse effects to you, unlike a judgment. So you know what you should do, defendant, is you should tell your insurance company to accept the settlement. That is another way to create leverage and create pressure. Hopefully that helps you. Let's see what else I had. I've seen some more pop up. Somebody said, and I'll come back to one that's not related, but are you using the phrase offer of settlement in place of the word demand? I think the offer of settlement in the state statute will offer of judgment. No, I think I understand this question. In federal court, there's an offer of judgment statute, which can only be used by defendants. The state court, Georgia, 9/11/68 offer of judgment, which I believe, sure as heck believe, can be used with can be used in state court as well as federal court. That offer, that statute, allows for an offer of settlement and an offer of judgment. You can pick from 9/11/68 what the terms of your offer are going to be, and your offer can be, I will settle the case under these terms, or we want a judgment. That is the term. We want a judgment. So an offer of settlement and offer of judgment are both contained under 9/11/68. Hopefully that helps. Jumping back to an earlier question as well, and I'm just reading the comment. Yeah, 9/11/68 is labeled offer of settlement as in the title, but you can, 9/11/68 is also the authority for an offer of judgment. You can pick as the plaintiff's lawyer. Two things I want to mention. One, going back to the UM question, I do not believe I do not believe that offers of judgment or offers of settlement under 91168 are appropriate, are allowed when it is a UM. And the reason is, and this is off the top of my head, 91168 says that a party can make. So in your traditional case where the UM is defending in the name of the defendant, I don't think the UM can make an offer of judgment or an offer of settlement. If you get one, to me, I either say, no, you can't do that. Or I make one back and say, well, I don't think we can do this, but I'm going to do one too. And now you've opened yourself up for liability as well. If the UM, though, defends in its, and this is the gray area, I don't know of a case on this, and maybe I should have looked before I say this, but I'll say it anyway. In the UM context, a UM can defend in their own name. Classic example is a DUI case or a hit and run case. The UM is not going to want to defend in the name of Karen, who Karen was drunk and then hit and ran and is just a terrible person, because they think that defending in their own name as an insurance company is going to, reduce the verdict for them. So in that case, when a UM says they are defending in their own name, well, then you can substitute them as a party or add them as a party. And then you can send, at least my approach is, you can send an offer of settlement or judgment to the UM once they become a party. All right, so keep that in mind. I saw a question here too about if a client underwent 2 accidents within a short period of time, strike one. And in the second settlement, if the opposition alleges that the first accident is the cause of the injury, what can the best arguments can be made? I think this is a classic timeline situation. You need to create a timeline of when the crashes happened, along with what medical treatment was sought and provided and what complaints were made. And I think you need to really look at that and say, can I prove that the first crash was the cause, or if you prefer the second crash, whichever one you are looking at, where do these symptoms and where are these medical injuries, where are those really related to? And of course, you need to get expert testimony, depending on the type of injury. You need expert testimony about, the cause of the injuries. So I think in that, in a multiple crash case where there's multiple crashes in a small amount of time and there's this, dispute, I am generally shying away from those cases. They make me very nervous because I think you lose a lot of pressure, because I think it is very reasonable. Again, in this imaginary situation, it's reasonable for the insurance company to say, we think it was crash 1 that caused the injuries, or we think it was crash 2 that caused the injuries. And you're on the opposite of that. What leverage do you really have if they have a reasonable basis to say, no, we don't think so? Your only real end game here is to take a settlement that is proportionally less than what it would be if there was only one crash. You have to factor in the risk that the jury agrees with the other side, or you're having a trial, which is fine, but of course you are spending time, resources, and waiting a long time for that. So I don't have a great answer to how to play those two off, other than really focus on what the true, honest answer is. And you should be doing that anyway, but really focus on what the true, honest answer is by looking at the medical evidence and looking at a timeline, and then, decide what you want to do about the case. And in my world, a lot of times that is, unless, there's a huge injury, I'm shying away from those because they bring a lot of trouble and a lot of difficulty, and they create a lot of risk to you. Frankly, the pressure gets put on you to make the case, which you have to do anyway, but to make a case when it's a very challenging factual scenario. Everyone, I've gone too long. I apologize and I appreciate y'all hanging in here. We're now almost at an hour and 10 minutes. I even thought about saying this is going to be a short one because I'm going to go through these as quickly as possible. Hopefully, you didn't get too bored, and hopefully you learned a little bit. My goal here is always to hopefully have you learn one thing, or even remind you of one thing that, like when I read my letter the other day to my team, like I said, I looked back and I reminded myself of things I know. So my message to you is to share. I've been doing these webinars now for over 2 years. I was looking at emails the other day, preparing for this, and also just in general of my team. And I get a lot of value from sharing with other people, because what happens is they share back with you. They share back with you. I think that when you are a plaintiff's lawyer, or when you work for a small business, or when you have a small, let's say even a small close group of friends on a personal level, when you start sharing in those scenarios with people outside of your group, with strangers, or with people that you look up to, or people that you want to work with, whatever the case is, I think that the benefits from that are incredible. So I want to end this by saying thank you, not just for joining this webinar, but to anybody who watches this. Thank you guys for joining me now 2 years, almost 2.5 years after I started these webinars. I have benefited probably the most from all these webinars by sharing with other people. The amount of information that has been shared back with me has been incredible. So find a way. And of course, I'll be blunt. I do this for marketing. At least the main reason I do this is for marketing purposes. I want people to share their cases with me. But even that aside, the information that people have told me, because I have shared things with them, has really changed the way that I practice in a lot of areas, and the way I think about walking through life. So when I learn something that's really good, like frankly, I'm going to give myself some credit here. I think my offer of judgment, offer of settlement at the same time with an explanation letter, I think that's freaking brilliant sometimes, depending on the scenario. I think is an awesome way to put pressure, because, for all the reasons I said, I won't go back through them. I could have, and 4 years ago, I probably would have sat on my hands and never told anybody that, and not wanted anyone to know that. I think I have a great demand for a pre-suit car case. A lot of people do, but 5 years ago, 6 years ago, I probably wouldn't have shared that with the masses. Since then, I've emailed it to, I don't know, literally thousands of people. I think I put it on a mass email I sent out to thousands of people. My gentle recommendation to you, certainly not telling you how to live your life or practice your business, is the more you share, the more you get. So I will end this by saying thank you for allowing me to share with you, and thank you for sharing with me. I hope that you will join me in the next webinar, and I look forward to hopefully having some more information that I can share with you. It's getting tough. It's getting tough 2 years later, but the more that I do this, the more I realize that this is a valuable experience for you, hopefully for you, but it is for me too. So thank you very much, and enjoy the rest of your week. Enjoy, if you have kids, enjoy the last weeks of summer. So adios, everybody.